Oh yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. You may be seated.
Good morning. Hope everybody's appreciating the rain that we finally got. Just a reminder that the cases, unless the court has put an order down otherwise, the cases will be live streamed. Oral argument will be live streamed, and then the oral argument will be placed on the Administrative Office of the Court's YouTube site. Call the first case, please.
Kevin W. Addis et al. Versus Evil CDI Inc.
We'll hear from the appellant.
Morning.
Good morning.
May it please the court. My name is Clinton Little, and I'm here along with Matthew Evans representing the appellants in this case. And I'd like to reserve 5 minutes.
That'll be fine.
Thank you. Your Honors, this case turns on two central questions. Primarily, did the parties in this case agree to adopt the Federal Arbitration Act or the Tennessee Uniform Arbitration Act? State law versus federal law. And to a lesser extent, did the trial court have subject matter jurisdiction with which to award attorney's fees? This case probably requires a little bit of procedural history to get us to where we are today. Around 2017, the parties began negotiating for the construction of a new home. And throughout the course of those negotiations, several estimates were provided by the contractor. They were all rejected as being too high. They finally settled on a price just a little north of $375,000. The contract was a cost-plus contract, no guaranteed maximum, and after the construction was complete, the final numbers came in, and the bill was much higher than the appellants had anticipated. So a dispute arose, and the appellee unilaterally initiated an arbitration action, filed a claim with the AAA, and appellants eventually got notice of that and responded as they were required to, but they responded under strict written protest. That's found in their answer to the arbitration claim. Before arbitration commenced, the appellants filed a deck action. They alleged that there was fraud in the inducement. So issue as to the formation of the contract. They filed that in Chancery Court. That stayed the arbitration while that case was pending. At some point, the appellants non-suited their deck action, proceeded with arbitration, maintaining their strict protest. The appellants did not bring a claim of fraudulent inducement or any issue as to contract formation in arbitration. That was intentional. They did not want to submit that to arbitration because they did not believe that that was arbitrable. They thought that had to be litigated. Arbitration commenced, and before the one-year saving statute expired, the appellants refiled their deck action. And through the course of the pendency of that action,
Well, the arbitration commenced and it proceeded to an award.
Yes, Your Honor. The award's not been confirmed, but
Understand.
the arbitration did result in an award. And so the trial court, sua sponte, questioned whether it had subject matter jurisdiction to hear this. And so the parties briefed the matter. Appellee filed a motion to dismiss based on lack of subject matter jurisdiction. And ultimately, trial court held that it did not have subject matter jurisdiction. The reason is because the trial court found that the Federal Arbitration Act, as opposed to the Tennessee Uniform Arbitration Act, controlled. And the way the court got there was that, it looked at a few things, but the parties' contract did a few things. adopted Tennessee state law, adopted the AAA rules, and the contract said any issues or any disputes that arise among or under the contract have to be submitted to arbitration. And that's where the parties and the case law and everything gets a little messy. There are 3 cases that sort of got us here under the TUAA. All of these were cited in our principal brief or our reply brief. You've got Frizzell Construction Company versus Gatlinburg LLC. That's probably the seminal case on this subject matter from our Tennessee Supreme Court. Then you've got Hubert versus Turnberry Homes LLC. And then you've got City of Blaine versus John Coleman Hayes and Associates. All of those contracts had very similar features to the contract in this case, in that they adopt state law, they adopt the AAA rules, and none of these contracts had any mention of the Federal Arbitration Act. On the flip side, there are 2 cases that are important for the Federal Arbitration Act analysis. You've got Taylor versus Butler and Elliott versus Icon in the Gulch. In both of those contracts, the Federal Arbitration Act was expressly adopted. I think in Taylor, the AAA rules were adopted, but again, those cases turned on the express adoption of the Federal Arbitration Act. And so, why that's important is, as we know, issues of contract formation under the Federal Arbitration Act are submitted to arbitration. This can't be litigated. Under the Tennessee Uniform Arbitration Act, they are litigated. It's a little illogical under the Federal Act that you can have a fraudulent inducement on the front end of that contract that would void the contract, yet the arbitration provision is still enforced. I think Tennessee gets it right there in that issues of formation have to go to court. And so the trial court labored over this for a while and ultimately settled on the adoption of the AAA rules and certain provisions within the AAA rules that, I don't mean this disrespectfully, but self-servingly say that, and conveniently will say that contract formation issues have to go to the arbitrator. Of course they say that. But Tennessee substantive law overrides that and says, no, those have to be litigated. But the trial court, there was a little bit of an evolution there. At first, there was a motion to alter or amend. So we're actually in front of the court twice on this, but you have you've got the adoption of the AAA rules with express adoption of Tennessee state law. No mention of federal law whatsoever. But the trial court examined Frizzell very, very thoroughly, and initially, dicta, but said the Frizzell contract did not adopt or must not have adopted the AAA rules because it didn't say anything. The Tennessee Supreme Court didn't say anything about the AAA rules. Lo and behold, the Frizzell contract did adopt the AAA rules, and the Tennessee Supreme Court thought so much of it, it didn't mention it in its opinion. The Court of Appeals did, but not the Tennessee Supreme Court. Again, the trial court didn't make a specific finding of that. This was just all, all in discussions in court. So when we went back in front of the court on the motion to alter amend, and we said, it turns out the Frizzell contract did adopt the AAA rules. Therefore, the contract in our case is almost identical. The provisions aren't word for word, but the substantive matter, substantive portions of that are identical. They all have those same features. But the trial court looked past that and ultimately held that federal law governed, and this dispute over contract formation had to go to arbitration. After the trial court dismissed this action, Appley filed a motion for attorney's fees. There is an attorney's fees provision in the contract. And so the trial court said, I don't have subject matter jurisdiction to hear the formation dispute, but apparently I do to hear the attorney's fees. Now, in the arbitration, Appley submitted a claim for attorney's fees in the first fraud deck action that was non-suited, and that was part of the award. The trial court granted attorney's fees on the second deck action, the one that was refiled under the savings statute. And so you've got this problem where you've got an award of attorney's fees from the arbitrator. Now you've got an award of attorney's fees from the trial court after the trial court said it had no subject matter jurisdiction to hear this. And so our argument is that the appellee should be judicially estopped from taking the position that the trial court had the subject matter jurisdiction to award attorney's fees in the deck action because it took the opposite position in arbitration, that all issues, any dispute whatsoever under the contract has to be arbitrated. And that's my time.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
Good morning. May it please the court, Your Honors. Chief Justice, my name is Andy Roskin, and I represent Appellee Eagle CDI. If you have any questions regarding the brief that we've submitted or the argument, please ask. Eagle CDI takes the position that this court should find that the trial court did not have subject matter jurisdiction and correctly dismiss petitioner's complaint. Further, this court should conclude that the trial court maintained jurisdiction, contrary to what we just heard, that the trial court did in fact maintain jurisdiction to award Eagle its reasonable attorney's fees, and that the trial court did not abuse its discretion in making the award. Finally, Eagle asks that this court award Eagle its reasonable fees and costs associated with this appeal. As to the issue of subject matter jurisdiction, as has been detailed in our brief and is obviously in the court's record, arbitration commenced based on the contract between the parties. After arbitration commenced, in fact, about a month before arbitration was supposed to occur, petitioners filed what we have called Fraud 1. With Fraud 1, they asked for a TRO. The trial court granted the TRO and stopped the parties from going to arbitration in February and set the arbitration date for the trial date on Fraud 1. It was continued to May. On the eve of trial, petitioners voluntarily dismissed their Fraud 1 case. By doing that, the TRO went away, and then the parties voluntarily went to arbitration in August of 2020, where they, for 3.5 days, submitted all claims and defenses that the parties had against each other relating to the contract and the terms of that contract. Petitioners raised fraud claims in arbitration, and in fact dismissed those claims during arbitration. Eagle CDI then filed their confirmation proceeding. In May of 2021, petitioners filed what we have referred to as Fraud 2, again asking the court to dismiss the complaint or to strike the contract alleging fraudulent inducement. Now, this is after the parties had already voluntarily gone to arbitration. So when we hear and we read phrases like under strict protest, unless there's a case that's been cited or some issue of what that means, we've yet to figure it out, and the trial court even tried to address that, what strict protest means when you voluntarily dismiss your case. Well, you file your case, you get the initial relief you wanted, which is to stay arbitration, dismiss it, and then voluntarily go to arbitration. The reliance on Fazell in this case is misplaced, in part because of something that the petitioners have argued here and what they agreed to in front of the trial court, and that is that the FAA applies. And that is found in the transcript of the evidence, and the first transcript of the evidence, and it is cited in our brief, where the trial court asked, And petitioners agreed if the FAA applies. They said, yes, the FAA does apply. Now, in the Butler case, the Butler Tennessee Supreme Court case, the issue that Butler tried to deal with in trying to kind of make sense of where Fizell came out, another Tennessee Supreme Court case, and Butler is, well, what do you do when the FAA applies, but you have a sentence that says Tennessee state law should apply under the contract? There seems to be some equivocation in both Butler and Fizell in how to determine what the intent of the parties was meant to be when they include arbitration provisions and that a state law would apply. And although not necessarily binding on this court, there have been a host of decisions in other courts, and specifically federal courts, looking at that issue that have said, well, that's too narrow of a view, that's too arbitrary of a view to say, well, the parties must have intended that Tennessee law applies. And really, what that seems to suggest is that although the parties can say we go to arbitration under the FAA, really what we mean is we want portions of Tennessee UAA to apply. But neither Butler nor Fizell actually reached that conclusion. They seem to suggest that if it's not expressly excluded from arbitration, well, let me rephrase that. Butler and Fizell seem to indicate you don't need to exclude anything if you say Tennessee law applies. Other cases have looked at that and said that doesn't make logical sense if we're trying to give intent to the parties. That why wouldn't they expressly exclude the idea of contract formation? And we know that in part because, again, petitioners agree the FAA applies. And two, we have the acts of the parties. And in the Derryberry versus Hill case, which is Tennessee Court of Appeals decision from 1987, the Court of Appeals looked and said, well, what did the parties do? And it's informative that the Court of Appeals said that if you're trying to avoid a contract because of fraud, quote, if you acquiesce in the contract expressly or do any act importing an intention to stand by it or remain silent under circumstances which plainly indicate a continuing assent to the contract. There can be no dispute that that's what petitioners have done. They dismissed their case. Eagle CDI argued in Fraud 1 that the court didn't have subject matter jurisdiction, but when they voluntarily dismissed, the issue became moot. But when you voluntarily dismiss and then you show up at arbitration, you are acquiescing. You are acting in conformity with what the parties intended to occur. That's what Derryberry speaks to. And in fact, it cites a case from 1870.
Counsel, just a point of clarification on a procedural issue. During the arbitration, petitioners withdrew the issue of fraud in the inducement, the contract formation issue?
No, Your Honor. They raised multiple fraud claims, primarily under the Tennessee Consumer Protection Act. So they raised fraud claims. They did not, as a defense in the arbitration, raise fraudulent inducement. They neither raised it as a shield or a sword in the arbitration.
So there were other fraud claims?
Yes, Your
which
Honor.
were initially
Yes.
pled or asserted and then withdrawn?
Yes, they raised 3 Tennessee Consumer Protection Act claims, and then prior to closing arguments, they waived and dismissed those fraud claims So the arbitrator never had the opportunity to rule on them. Is that?
Thank you.
Counsel, if the 51,000 change that was awarded, what, did that include just matters that attorney fees that were related to what happened in court, or did it include attorney fees that happened in the arbitration?
No, Your Honor, that the attorney fee award only dealt with fees that were generated during the defense of the Fraud 2 case.
In court? The attorney time for matters before the trial court?
Yes,
Not the arbitration?
correct. Only for
Okay.
issues in defending the Fraud 2 complaint. As you can see in the record, by the time Fraud 2, again, our term for it was filed in May, and this ultimately was set for trial, a year and a half later in December is when the court ultimately took up the issue of subject matter jurisdiction. A hearing was had on that specific issue regarding attorney's fees, and petitioners had the opportunity, and in fact did, and it's in the record, where they had the ability to question the veracity of the fees and how the fees were generated. And the court, as this court knows, and contrary to the argument offered by petitioners, our Tennessee Supreme Court, as late as 2020, has ruled that even when a trial court does not have subject matter jurisdiction, it still retains jurisdiction to take up the issue of attorney's fees. So the issue then becomes, we know the court had authority, and then the analysis is, did the court abuse its discretion in awarding those fees, as opposed to the first issue, which this court would take up de novo. This court should not disrupt the fee award granted by the trial court. There's been no showing, in fact, there's been no argument by petitioners that the trial court abused its discretion in awarding those fees. And again, this was after a hearing on the issue of attorney's fees, where the court was in the position to then understand how the fees were generated and made a determination based on the factors as outlined in its order on whether they were fair and reasonable. And without us showing that there was an abuse of discretion, this court should not disrupt or amend those awards. I don't want to belabor a point here. The trial court did not have subject matter jurisdiction on this. Parties cannot be allowed in our state to request relief from a court, get it correctly or incorrectly on the Fraud 1 case and the TRO that went down, dismiss the very thing they wanted, go to arbitration, lose, and then decide, let's raise fraudulent inducement again. When you act in conformity per the Derryberry decision, then we can rely on that action in conformity, and you don't get to come back in and say, we want a do-over. So this court should find on its de novo review that the trial court did not have subject matter jurisdiction in this case. Secondly, we ask that this court uphold the attorney fees that were awarded in the trial court. And lastly, we ask that this court consider authorizing Eagle CDI to recover its fees and costs associated with defending this appeal. If there are no further questions, that will conclude my argument.
I hear none.
Thank you.
We'll hear from the appellant rebuttal.
Thank you, Your Honor. So to circle back on a few points that a colleague mentioned here, this case got off on a strange footing from the beginning because, and this wasn't opposing counsel's fault, no motion to compel arbitration was ever filed. The appellee just unilaterally files a claim with the AAA, and in fact, the appellants didn't even know about it until I think after the time under the AAA rules expired to respond. And so what happens there is the appellants run the risk under the AAA rules of being defaulted So you have to do something. And so, the first thing we did, because the clock and when they received notice of the claim, had run, immediately filed a response. And again, that was under strict protest. In fact, in the answer to, I believe, fraud 2, could have been fraud 1, it's actually in our brief. It's volume 1, pages 70, and then 111 and 112 of the technical record. I believe did not deny that appellants were there under strict protest. In fact, I believe they said that without sufficient information to admit or deny it. And so I think that's key. So the notion that the appellants were participating in arbitration voluntarily, I think that's not correct. Strict protest, that's when they filed their first deck action. And then the arbitrator insisted on proceeding forward, so unfortunately we had to seek a temporary restraining order to enjoin that while we sorted this out in the trial court.
Excuse me for interrupting, counsel.
Yes, sir.
Procedurally, once again, after the injunction was granted by the trial court, then the appellant took a non-suit and went forward with arbitration. Is that correct?
Yes, Your Honor. I believe your question was, once the TRO was lifted upon the non-suit? Yes. Then the AAA immediately said, okay, you're coming back here now. And so, again, we made it very clear, we're here under strict protest only. I was a little surprised that a motion to compel arbitration wasn't filed, because that would have fleshed out all these issues. I think we would have faced claim preclusion, for example, if we didn't air these issues out at that point.
But there's no requirement that a motion to compel arbitration be filed, is there?
Your Honor, no, not that I could find. It just happens that all of these cases that are speak to this issue, every one of them.
Well, typically what happens is, in my understanding, is a lawsuit gets filed when there's an arbitration clause, and then whoever wants the arbitration will then file a motion to compel arbitration. This one went backwards, which is okay. There's nothing to prevent him or for the other side from invoking the arbitration clause and going ahead and filing.
Certainly.
That way.
It left this issue hanging out there, though. It would have funneled all those together, and they would have had to been dealt with. Although I did see one case where the party that insisted on arbitration did file a lawsuit first, and then when the other party countersued, then a motion to compel arbitration followed by the original plaintiff. And so,
But the arbitration had already been stayed, correct?
during the pendency of the fraud 1 case, yes, sir.
The arbitration was stayed, and it remained stayed until that suit was non-suited.
Correct, Your Honor.
Okay.
Correct. And then once that was non-suited, the AAA reached back out and said, here we go. And so, now as to the fraud claims being submitted to the arbitrator, I respectfully would disagree that those sounded in fraud. They were Tennessee Consumer Protection Act claims, unfair business practices, things like that. But the appellants were very intentional not to submit contract formation issues to the arbitrator. That was very intentional. And as we said before the saving statute ran, in fact, the appellants refiled their deck action. But before my time runs, the issue on the attorney's fees, I think is very important just to keep in mind. The appellee submitted a claim for attorney's fees to the arbitrator for fees incurred in Chancery Court on fraud 1, and then a claim for attorney's fees to the Chancery Court in fraud 2. So we have 2 different tribunals awarding attorney's fees for trial court actions. So that is my time. Thank you.
Thank you. Court's thanks to counsel for both sides. We appreciate your arguments and your briefs on this. Yes.